Jazmine.
Charmiane.
Is that Bree? Hi, Bree. James, wake up. It's time for contract. Come on.
Misrepresentation is when the claimant claims that he or she had relied on inaccurate information that was communicated by the defendant to him or her, and this inaccurate information caused the claimant to enter into the contract. Such a claim is based on the defendant's provision of false information to the claimant. On the other hand, a claim for pre-contractual non-disclosure is based on the defendant's failure to provide information. Therefore, the claim for non-disclosure is fundamentally different from the claim for misrepresentation, as in the case of mistake. The misunderstanding or lack of information caused by the defendant cannot be raised by the claimant. However, there is generally no duty to disclose material facts to another to a proposed contract under the English position, as evident in the case of Bell and Liver Brothers Limited, where it was emphasized by Lord Atkin that the failure of disclosure, which might potentially influence the mind of a prudent person, does not give the right to avoid the contract. However, even though there usually isn't an obligation for disclosure, there are certain types of transactions and relations where the duty to disclose is imposed. At the same time, it would be rather contradictory if a representation could be made by silence given the self-explanatory nature of contract law, especially in the light of caveat emptor, the principle which literally translates to buyer beware. Furthermore, as highlighted in Section 17, subsection B of the Contracts Act 1950, it provides for active concealment of facts and not mere situations of silence. It explains that mere silence as to facts is likely to affect the willingness of a person to enter into a contract. It's not fraud, unless the circumstances of the case are such that it is the duty of the person keeping silent to speak, or unless his silence in itself is equivalent to speech. Therefore, the general rule is that silence does not amount to fraud.
Contracts that are classified as uberrime fide of utmost good faith is a group of contracts where a duty to disclose information is imposed. This doctrine was established in the case of Carton and Bohm and subsequently affirmed in Rosanes and Bowen, where it was held that as long as the underwriter knows nothing and the man who comes to him to ask him to insure knows everything, there's a legal obligation to act in good faith and make full disclosure regardless if it was being requested or not. A notable example of such contracts would be insurance contract, where it includes marine insurance as well. In Pan Atlantic and Pine Top Insurance, it was held that there was no exception as to the duty to disclose. Moreover, this case also raised the question as to the nature of a material circumstance and the effect of its non-disclosure with reference to Section 18 of the Marine Insurance Act 1906, where onerous duties are placed upon parties to have every material circumstances disclosed as provided under Section 18, subsection 1, that the assured must disclose every material circumstance which is known to the insurer before the contract is concluded, and failure to make such disclosures would allow the insurer to avoid the contract. Followed by Section 18, subsection 2, providing that every circumstance is material which would influence the judgment of a prudent insurer in fixing the premium or determining whether the risk will be taken. However, even though the party applying for insurance will be likely to be the party with exclusive knowledge, in most cases, the duty to disclose information is nonetheless mutual. This is provided in Section 17 of the Act, which imposes the duty to either party, which can be seen to apply in Bank Kaiser and Scandia Insurance Company, where it was mentioned that the reciprocal duties of the utmost good faith are owed to one another by an insured and an insurer. In addition to that, the Marine Insurance Act is not only limited to marine insurance, as evident in March Cabaret Club and Casino Limited and London Assurance Limited, where Justice May stated that this statute's principle can be applied in non-marine insurance contracts too. Moving on, the duty to disclose information in relations of confidence arises from the nature between the parties to a contract in fiduciary relationships. Even though there isn't an exact legal definition for the word fiduciary, fiduciary relationship is generally known to be connected to trust, where parties have duties to act in the interest of another. In the context regarding the duty of disclosure, parties in a fiduciary relationships are said to have a duty to disclose important facts to a contract. In the case of Bular and Bular, where two company directors failed to inform the company about their purchase on a neighboring property they came across as passerby and was held liable for breaching the conflict rules as fiduciary has exploited a commercial opportunity for their own personal benefits. Similarly, in Crown Dilman and Sutton, where a director owed a duty when he exploited a relevant opportunity for the benefit of the company, but failed to make full disclosure to the company before it was consented. Significantly, in these cases, it was the director's failure to inform the company of the opportunity, combined with his subsequent exploitation of the existing fiduciary relationships in conflict with the company's interests, that rendered them liable. Besides, a misrepresentation may arise if the statement was true when it's made, but changes to become incorrect by the time it is acted upon due to a change in circumstances. In this situation, it's known as subsequent falsity or supervening falsification, where failure to disclose a change information that might affect the decision-making of the other party might amount to a misrepresentation. In the case of With and O'Fallaghan, it was held where when a statement is rendered false by a change in circumstances, there is a duty to disclose the change. If the truth or falsity of a representation is to be tested at the moment before it is acted upon, then it should follow that if a representation has been falsified without the maker's knowledge, in the interval between being made and being acted upon, the maker would be liable as for an innocent misrepresentation. In conclusion, even though the general rule is that there is no duty to disclose under the English position, as evident from the exceptions and statutes mentioned, there are still under certain circumstances where duty of disclosure plays a crucial part when an agreement or contract was made. Hence, it can be said that silence can after all amount to misrepresentation to a certain extent.
Under the Malaysian position, the prima facie rule is that there is no duty to disclosure. However, the common law exceptions in England are also applicable in Malaysia. Malaysian law also imposes an additional duty to disclose information if the non-disclosure would constitute fraud. Therefore, the important question is in what circumstances does the non-disclosure amount to fraud? There are two possible situations. Firstly, when there exists a duty for the person to speak, and secondly, when the silence itself is equivalent to speech. The first exception is where there is a duty of the person keeping silent to speak. This often occurs in sale and purchase transactions where the relationship between the parties is more than the ordinary relationship of seller and buyer. For example, in Karipanan Chelapan and Chong Li Chin, it showcases the principle of caveat emptor, otherwise known as let the buyer beware, as there is no duty for the vendor to speak, as the relationship between the parties were not more than the ordinary relationship of a seller and buyer. This implied principle is contained in Section 14 and Section 17 of the Sales of Goods Act 1957. Thus, it was ultimately held that the maxim caveat emptor applied to the plaintiff, as Abdul Hamid Embong Justice stated that there is no fiduciary relationship between a vendor and a purchaser. Therefore, an uncommunicative vendor cannot be at fault if he failed to disclose any patent defect. In addition, the Court of Appeal in Dato' Yap Pak Leong and Sababumi Sandakan Sendirian Berhad in 1997 upheld the application of implied terms, the Sale of Goods Act 1957, in circumstances involving the sale between the seller and buyer of goods. Thus, according to Shaikh Muhammad Noor Alam, the lack of absence of information will interfere and impact the ability of transactions. Overall, the basic doctrine of caveat emptor as a legislation affecting the sale of goods is no denying users can manifest injustice to the user. Furthermore, the second exception applies where silence is in itself equivalent to speech. It should be noted that silence is not the same as active concealment of a fact. The former is merely keeping quiet, which is not fraudulent unless it meets the two exceptions as previously mentioned, while the latter refers to positive actions of concealing facts. In both these circumstances, there are three elements of that must be present. Firstly, the intention to deceive must be present as it distinguishes fraud from innocent and negligent misrepresentations. This was affirmed by ancient justice in the case of BP Sabah Sdn Bhd and Syarikat Jibrin Enterprise, a partnership firm and owner, when he states that a person is deemed fraudulent if he acts with the intention to deceive someone and by doing so, an advantage should accrue to him, or injury, loss, or detriment should befall some other person. Section 17B of the Contracts Act 1950 provides that the other two elements. The second element is that there must be an active concealment of a fact. Thirdly, the concealment must be made by a person who has knowledge of it. These elements of fraud are especially important for contracts über reme fide or contracts requiring good faith, such as insurance. A failure to disclose material facts amounting to fraud would make the contract voidable at the option of the innocent party by virtue of Section 19, subsection 1 of the Contracts Act 1950. The case of Tay Say Ching and North British and Mercantile Insurance and Company defines material facts. The case categorizes material facts into physical hazards and moral hazards. Physical hazards are factors that contribute to the likelihood of loss. Moral hazards are factors that throw doubt onto the insured's integrity. For example, for insurance claims, insureds typically put forward an inflated claim with the intention to defraud the insurers. Such a claim can be defeated by the insurer on the basis of the insured's failure to act in good faith. However, it is a question of fact inferred from surrounding circumstances as to whether a particular claim is tainted with fraud. However, in some circumstances, fraud will not cause the contract to become voidable. The exceptions to Section 19 of the Contracts Act stipulate that silence equivalent to fraud will not render a contract voidable if the other party whose consent had been induced had means of discovering the truth with ordinary diligence. In other words, if a buyer could have easily discovered the fraud by non-disclosure, they cannot avoid the contract.
Now, let's talk about the flaws in the law regarding the duty to disclose. Among the circumstances where a duty to disclose is imposed is where there is a fiduciary relationship. This exception is concerning since there is no fiduciary relationship between vendor and purchaser in a negotiation. Hence, the purchaser is not bound to disclose any fact exclusively within his or her knowledge, which might reasonably be expected to influence the price of the subject matter. Being reserved during negotiations does not amount to legal fraud. This is a questionable issue and has been playing a controversial role in different disputes from years and years, as there is no value being served, economic or otherwise, by refusing to impose a duty to disclose the truth. Sure, there are arguments where a buyer could hire a professional to inspect the goods before purchase. However, this hardly justifies a seller's silence when it would have taken them no effort at all to disclose the condition of the item truthfully. Hence, it can be seen that the general rule where silence does not amount to misrepresentation enables unethical sellers to exploit unsuspecting buyers. A striking example of injustice would be the case of Wills and Wadham, in which the wife had no duty to disclose her plans to marry a wealthy man as soon as the divorce became absolute, despite being aware that the husband had agreed to a financial settlement only because of her financial dependence. This decision is now overruled, but only on the grounds that full disclosure is owed to the courts and not to the other party. Moreover, it can be said that the three exceptions regarding silence as misrepresentation provided by the common law practices are still considered as vague, ambiguous, and insufficient in many disputes. One of the exceptions is the rule of subsequent falsity, and there are also concerns with regards to subsequent falsity. This is because there is only a duty to disclose of the change in circumstances when change is known to the maker of the statement. On the contrary, when a change is unknown to the maker of the representation, there is no duty imposed upon them to disclose that change. The rationale behind this principle is put forward by Lord Justice Fletcher Moulton, and that is, the duty is a duty to disclose, and you cannot disclose what you do not know.
Let's talk about the concerns regarding ubima fide contracts. So the general rule regarding these sort of contracts is that there is a duty to disclose all material facts. So now the important question becomes, what is a material fact? In order to determine this, we use the test of materiality, namely the prudent insurer's test, which is currently widely implemented in England. Using this test, the court will take a perspective for a prudent insurer to determine whether the facts undisclosed by the insured would be material to the insurer. In other words, the court will rely upon the insurer to set the scope of information to be disclosed. However, the prudent insurer's test causes some concern because it allows the insurer to avoid an insurance policy for innocent, immaterial, non-disclosures of information. There are two reasons as to why the prudent insurer's test is unfair and should be reformed. Firstly, while insurance contracts contain statutory warnings regarding the duty of disclosure, it may not be very well effective. In most cases, consumers suffer a misconception that they only need to answer the questions posed by the insurers honestly and correctly. They are unaware of the fact that the prudent insurer's test also requires them to disclose information beyond the questions requested by the policy form. This is problematic because the insured falls short of the duty of disclosure required by law. Secondly, the prudent insurer's test cannot be accurately applied by the court because the courts simply lack the special knowledge of the industry to take the perspective of an insurer. In utilizing this test, the only way for the courts to ascertain whether the undisclosed information was material to a prudent insurer was to allow the insurance companies themselves to tender evidence on their own behalf and the views of other insurers as evidence. As such, there is a concern that the test is unfair because the courts are too reliant upon the insurers. In short, these factors mean that the insurers are in a more favorable position in comparison to the insured, which allows them to exploit the vulnerabilities of the insured's duty to disclose. In order to rectify this issue, the English court should follow the example set by Australia and utilize the reasonable insured's test. This test is similar to a reasonable man's test, which takes in the perspective of a reasonable person or insured to determine which facts are material to the risk they face. In other words, the courts rely upon the insured to set the scope for information to be disclosed. This will nullify the bias towards the insurers. Malaysia has already noticed the weaknesses of the prudent insurer's test, and therefore they had incorporated the reasonable insured's test through Section 150, Subsection 1 of the Insurance Act 1996. This act is based off the Australian model. However, the weakness with this act is that it does not incorporate all of the remedies in the event of a breach of the duty to disclose available in Australian law. The lack of available remedies result in a reliance upon the common law remedies of avoidance of a contract or refund of the premiums paid intact. This all or nothing approach is extremely harsh upon insureds whom have dealt with good faith and yet fell short of the material test. With a larger incentive to avoid contracts, insurers are more likely to claim that the insured had made a technical error in their disclosure and therefore reject the claim.
Moving on, I'll discuss the suggestions as to the reforms on the issues in the current law. In regards to the exception of subsequent falsity, the burden of risk upon the buyer between the time the representation was made and the agreement being concluded is unfair. Thus, a duty should be imposed upon the seller to ensure that their representations are accurate to the point in time where the agreement is concluded. On the contrary, the Law Commission has proposed several reforms for consumers of insurance. The first being that a consumer would no longer be obliged to volunteer information. Instead, they will only have a duty to respond honestly and with reasonable care of questions asked. Therefore, the focus will move to the quality of the questions. This new test will take into account of different types of policies, the way it was advertised and sold, and the normal characteristics of consumers in the market. Overall, the consumer's subjective circumstances could be taken into account, but only if the insurer was aware of them. On the other hand, under businesses, it was proposed that the insured's duty to voluntarily disclose and not misrepresent material information known to it or that it ought to have known should be retained. However, a new test for materiality would replace the prudent insurer with a reasonable insured. So, instead of asking whether the information was something that would influence the judgment of a prudent insurer, the question would have appreciated the insurer would want to know about. Thus, the reasonable insured test would take into account the type of the market, the questions asked, and whether the insured had professional advice. Next, based on remedies for breaching consumer insurances, the remedy of avoidance for an inaccurate or misleading statement would be replaced depending on the degree of fault. Since a consumer would be presumed to know what someone in their position would expect to know, and if an insurer asks a clear question about something, the insured would be presumed to know it was relevant. Therefore, under the consumer regime in the business context, the insurer would have no remedy if the insurer acted honestly and reasonably. Then, for warranties, the solution proposed for both consumer and business insurance is a requirement for a causal connection. In order for the insurer to avoid paying all or part of the claim, the breach must have caused or contributed to all or part of the loss. So, if there was no such connection, the insured would be entitled to be paid in full. In addition, for more serious breaches, the insurer would have a separate right to terminate the policy of future, as there would be additional protections. In terms of warranties in consumer insurance, it will be limited to warranties of future fact, which have to be in writing. The insurers will also have to show they took sufficient steps to draw them to the insured's attention. Furthermore, for both businesses and consumer insurances, the consultation paper proposed to abolish all basis of the contract clauses, which are clauses that automatically transform statements made by the insured into warranties.
Furthermore, the consumer's protection provided by the Consumer Protection Act 1999 is not absolute protection, as there are several provisions that excludes the liability of the supplier and manufacturer in the market world. Therefore, the buyer still has to be aware in purchasing the goods, and the government has to take the good, fast steps to solve the problems before it happens and to improve the provisions in the statutes to be more comprehensive in order to protect the consumers and provide justice in both parties in making their contracts. On the other hand, it can be seen that Malaysian law remains static around caveat emptor, especially in real estate transactions. While other jurisdictions have acknowledged the implied warranty and imposes a duty on the seller to disclose material conditions that will affect the buyer's decision to buy, that has not been the case for Malaysia. The court in Hadley Arthur John emphasized that the seller has no legal duty to disclose any defects and makes no warranty about the state and condition of the property being sold. Reforms that should be made would include the repeal of Section 62 of the Sales and Goods Act 1957, which allows the exclusion of implied terms. Moreover, since the purpose of disclosure is to inform the purchaser of matters relevant to the decision to buy the property, hence, it is submitted that the ideal time to deliver the statement to the prospective buyer when the offer to purchase has been made by the prospective buyer. The disclosure should not occur at the later stage of the transaction. Unlike countries like the United States and Australia, in Malaysia, there is no legislation on vendor disclosure law. Hence, prospective home buyers in Malaysia must rely on scattered sources of information, such as the land title search, valuation reports, and building inspection reports made by building surveyors. Vendor disclosure law should be implemented in Malaysia and impose a legal obligation to disclose information regarding the physical and social conditions of the property prior to the transaction.
In conclusion, the prima facie rule is that there is no general duty to disclose information for both English and Malaysian law. This rule is justified by the principle of caveat emptor, or let the buyer beware. Under English law, there are 3 exceptions to this prima facie rule. These exceptions include contracts involving ubi rumah fide, contracts involving fiduciary relationships, and where subsequent falsity occurs. The Malaysian law also applies these common law exceptions. In addition, they also impose a duty to disclose information if the non-disclosure of such information would result in fraud under Section 17 of the Contracts Act 1950. However, there are several flaws in the current law for both English and Malaysian position that requires reform. One such flaw exists in the law relating to subsequent falsity. The law should be reformed to impose a duty upon the misrepresenter to discover and disclose the changed circumstances. In English law, contracts ubi rumah fide, specifically in insurance contracts, the English courts should adopt the reasonable insured's test, whereas in Malaysian law, the courts should also provide a wider range of remedies that are proportional to the degree of misrepresentation instead of the all or nothing approach. Lastly, on the principle of caveat emptor, the Malaysian courts should be less reliant on this principle and be more frequent in their imposition of a duty to disclose.